Okay, so I was suggesting to start is 3:34, so 4 minutes. Okay, so good afternoon to all of you. So we are in a new webinar of Indo-Spanish Chamber of Commerce. In this case, is hosted by PSL. And we have been trying to get a new something that we deem can be interested for some companies that are involved in some problems or legal issues when they operating in India. So we have seen some interest about these sort of topics. So that is the reason why we thought this was a good idea, a good webinar. Not for all of us, because for instance, not all of us have legal issues, but it's not something that if we don't have today, we will not be having on the future. So it's better to have information to show how to tackle this. So in this case, we are going to speak about the arbitral awards and appeals, some recent developments that may be interesting because of that, because it means an evolution and a change. And we have Mr. Samir Jain, Managing Partner, Dispute Resolution of PSL, and Mr. Angad Sandhu, Partner, Dispute Resolution as well of PSL. So apart from that, last activity that we have was some time ago. We have not been doing in the last 3 months because of the problem of the pandemic in India. We thought that all of our companies were involved on tackling the difficult situation that we have been living, not only in the country, but in the personal, family, and the professional field. So now that things seems to be better or slightly recovering, though with some scars that all of us have suffered, let's try to come to this new reality, this virtual world, and let's try to maintain what we had. There are webinars every 2 months. So in this case, we will be trying to maintain it, and hopefully, as we told, and along this financial year, we will be able to start doing something physical. Apart from that, let me have some words for Ankur Bhatia, that was a member of the chamber, was one of the initial members of the chamber when we started the growth, and that regrettably has passed away as a consequence of COVID, as we communicated in the LinkedIn group. So having told that, please, Samir, Angad, over to you. Thank you very much for the opportunity of this webinar, and I hope that everybody likes it. Thank you.
Thank you, Oscar. And hello, everyone. I agree with Oscar. You know, these are very, very trying times, and I think there's no one who's not been affected by it. There's no family which has not been affected by it. And we just hope that this phase passes on, and as they say, the show must go on. And we certainly, I certainly know that we as a race are very resilient, and we shall overcome this. Also, Oscar said that a lot of us do not have legal issues, and that's a good sign. As lawyers, you know, we always say that it's good not to have legal issues facing you, but in case you do, then it's important to be on the right side of the law, and that's the basic idea of today's presentation, and it's specifically focused at setting aside of arbitral awards and appeals. And to give you a very, very brief background, since the arbitration is just another mode of dispute resolution, it's important to understand that there is not a very, very huge difference, except that of the procedure. The basic difference between arbitration and court litigation is that you choose who would judge your case. there's complete party autonomy. You can choose where to arbitrate. You can choose with whom to arbitrate. You can choose which institution will govern it. And this is predominantly quite prevalent with international trade transactions, because of the reason that the parties are able to choose a neutral venue while resolving their dispute. For example, very recently we acted as a counsel for a company in India which had a trade transaction with a company in Norway, and we did the arbitration in Paris through an arbitrator who was seated in Dubai, educated in UK, and we had German counsels from the opposite side. So that's the interesting part of arbitration. You can really tailor-make your complete dispute resolution mechanism, and that's the striking difference between litigation and arbitration in India. Having said that, very briefly, in India specifically, we still have the panchayat system. That's more or less the genesis of the whole arbitration regime. And the idea was to have a very amicable dispute resolution mechanism. But of course, over the period of time with the Arbitration Act in 1899 and the 1940 and the 1996 Act, which is the current law, most of it has been and revised. There are now strict rules of procedure. There's strict substantive law issues which govern the arbitration. And why we always emphasize as a firm to for people to understand the difference between an appeal and a challenge and what happens in an arbitration is something which I would like to talk about in this particular presentation. Now, the basic steps, in an arbitration proceeding is, of course, execution arbitration agreement. Now, it's important, and I think everyone is aware that for the parties to be able to arbitrate, there has to be an arbitration agreement. Most of the time, this arbitration agreement is embedded in the main agreement. There's an arbitration clause through which the parties then end up arbitrating in case of a dispute. So once you have an arbitration agreement and a dispute, you get an arbitrator appointed. Now, there are multiple ways in which an arbitrator can be appointed. There may be one arbitrator, there may be three, there may be five, and the clause would probably determine in most cases as to how and who will appoint an arbitrator. Now, in a three arbitrator system, it normally both parties appoint one arbitrator and then both arbitrators appoint the presiding arbitrator. Till very recently, in a sole arbitrator clause, either of the parties had a right to appoint an arbitrator. Very interestingly, I must highlight is the recent Supreme Court judgment in Perkins, where the Supreme Court of India has said that any clause which has a unilateral appointment mechanism is bad in law. So it's a good news for people who are having contracts with Indian PSUs or Indian government, which invariably had a clause where the PSU or the bigger company had the right or retained the right to appoint an arbitrator. All of that is gone now. Even if your contract says that XYZ party to the contract will appoint an arbitrator, they can't. So either parties agree together to appoint an arbitrator, or they approach the court and get an independent arbitrator appointed. Of course, after the arbitral the tribunal is constituted, there are arbitral proceedings, which now have to finish within a period of 12 months. There's an extension of 6 months from there. So within 18 months, the arbitral proceedings need to end. In very exceptional cases, you can go to the court and get the timeline extended. This is a very, very recent amendment, and therefore has brought in a lot of certainty in terms of the timeline within which you can really arbitrate your disputes. Once you have the arbitral award, that is when the whole genesis of this presentation comes in, and there is a challenge to that arbitral award. You would notice that I'm not seeing there's an appeal, it's a challenge. And that's where the core difference between the litigation and arbitration comes in. Now, when I say there's a challenge to an arbitration award and not an appeal, that means that there are very, very limited grounds on which you can really challenge the validity of an arbitral award and set it aside. It's not like an appeal. You cannot agitate merits of the case. The challenge court, unlike the appellate court, does not have the right to look into the merits of the case or reappreciate the evidence. And there are only grounds which we will discuss a little later, which would essentially showcase on what grounds you can challenge it. And therefore, ladies and gentlemen, I always advise people to make sure that the first instance of arbitration is done properly, is handled with utmost care and precision, because once an arbitral award is out, you cannot bring in new evidence, you cannot reappreciate the facts of the case, you cannot reappreciate the law. The Supreme Court is extremely clear that the courts do not have the right to reappreciate or go behind the mind of the arbitrator and adjudge whether what he said is right or wrong. The courts have also said if there are two plausible outcomes or after appreciating the evidence, the court will not say which one is right or which one is wrong. What the arbitrator has decided is sacrosanct, more or less. And therefore, the proceedings of arbitration are the core of you handling the dispute, and there cannot be any laxity in that. In typical litigation, we see that even up till the Supreme Court, even if you do that at trial court and then you go to the High Court and appeal and then you go to the Supreme Court, there have been instances where the Supreme Court has allowed new evidence to come in which could not be placed on record due to some negligence of the counsel or negligence of the party. That's the benefit of an appeal, because there are unfettered rights to the court, but not in an arbitration challenge. Now, Section 34 of the Arbitration Act provides for challenge of the arbitral award, and the grounds which Section 34 provides under a challenge are these. Now, some of the grounds are that if the party is in some incapacity, or the arbitration agreement under which arbitration has happened is an invalid agreement, in case there was no proper notice to the party which is challenging the award, either of the appointment or the arbitral proceedings, if the award is vitiated by limitation, and if the reference to the arbitration is beyond the scope of the disputes which can be taken to arbitration. Now, for example, in India, and mostly non-common law jurisdictions, criminal offenses cannot be arbitrated, or any right which would affect third parties to the arbitration agreement cannot be done, such as intellectual property rights, such as rights in the real estate property. So these are some cases where arbitration is not allowed. So just, Angad, can you just go back one slide? Right. So when we talk about party incapacity, it relates to a mental incapacity of the person who's executing the agreement, or legal incapacity such as being a minor. In case of a company, it can be that the person who signed the agreement was not authorized by the board and he was thus incapable. However, the onus of proof would be huge to prove incapacity in that case. Now, defective notice of party precluded from representing his case would mean that there was an arbitration initiated, but the notice of arbitration could not be received, and therefore that is another ground. Invalidity can mean several things. Some of the examples can be when the contract was not properly concluded, it was not properly executed, or the agreement is void or voidable under the Contract Act. But in those cases also, interestingly, the courts have time and again said that the arbitration clause in an agreement is separate from the main agreement itself. So even in those cases, sometimes there may be instances where the arbitration can progress even when the main agreement or some parts of the main agreements have been held to be invalid. Now, I have already explained what the outside terms of reference means. The contract normally talks about what can be subjected to arbitration. And then there are judicial and common law bases as to what can be arbitrated and what cannot be arbitrated. Composition of arbitral tribunal, I've already stated there are various case laws and hugely developed jurisprudence as to who can arbitrate and who cannot arbitrate. You also need to take care that if there is an ongoing arbitration where an arbitrator has been appointed by one of the parties and you agree with that, you're still time to approach the court and get a new arbitrator appointed. Because if you don't, then the concept of waiver might kick in, which would then mean that you may not be able to take that challenge or take the ground at the time of a challenge. So act right now if there is an arbitration going on and you have to challenge the appointment of an arbitrator. I've already discussed what arbitrable and non-arbitrable disputes are. And as I go forward, I would request that whatever doubts you have about what we are saying and what we are telling, you can just write it in the chat box and we will address them at the end of this presentation. Now, the law in India talks about public policy and patent illegality. Now, these are words which have been used in Section 34, which are one of the main grounds on which you can challenge the arbitral award. Now, the terms public policy and patent illegality sounds really heavy to the layman, to a non-lawyer, even to most of the lawyers, because it's something which not dealt with on a daily basis. Now, this whole interpretation was subjected to quite naturally to a lot of litigation as to what would be public policy, what would not be public policy, whether a simpliciter violation of any law would be in violation of public policy. Now, very recently, we saw this in one of the enforcement of an international arbitral award, where it was contended that if the arbitral award was to be paid to the entity outside India, or if there would have been compliance of the agreement, it would violate the FEMA laws, because FEMA doesn't allow repatriation or expatriation of money in a particular fashion. And it was then challenged on the grounds that, because it's in violation of FEMA, it's a violation of public policy. And interestingly, the Delhi High Court and then, of course, the Supreme Court also said that merely because an arbitral award or satisfaction of an agreement would violate a particular law of India, all of which would not be a violation of the public policy. Public policy has to be something really fundamental, has to be really something which would violate the most basic notion of morality and justice. And again, these are not, and I understand these are very fair and wavery words, but that's how the law is for everyone. So the basic understanding you need to have is that not every violation of law in India would be a violation of the public policy. And so patent illegality, every violation of the law would then be covered in the whole concept of patent illegality. Now, there you can challenge the award on the basis of violation of a particular law. Now, you would think that, okay, if not public policy, then patent illegality, I have that ground available to me anyways. Now, the interesting part to note is that patent illegality is a ground available to awards which are passed in India and are seated in India. Now, in an international commercial arbitration, which means that where either of the party is not seated outside India, seated in India, those awards would be called international commercial arbitrations. Now, the ground of patent illegality, and mark my words, is not available to awards which are challenged by people which are subject matter of an international commercial arbitration. Now, while most of the companies may, when they have an arbitration, may arbitrate through their Indian arm or through their Spanish arms or any other international body, and So please make sure that when you have a challenge or there is an award which is being challenged against you, and it is an international commercial arbitration, make sure that your lawyer takes care of the case, takes care of the fact that patent illegality is not a ground available to challenge an international commercial arbitration. And can we have the next slide? Well, judicial approach, I would so 2015 is the year when we saw a huge jump or huge progression in the law of international law of arbitration in India. There was a massive amendment carried out in the 1996 Act, and a lot of the hurdles or a lot of the speed bumps which were hampering the progress of India as a hub of arbitration or as a very arbitration-friendly jurisdiction were paved, and the potholes were filled, and the law was made quite progressive. So, and you know, there are cases which have been good laws since 1994 and the 1980s in arbitration. So one such case is Renu Sagar Power versus General Electric, which reiterated or discussed the concept of public policy, and as I said, has given a very restricted meaning to public policy, and any and every violation would not be a violation of the public policy. So it has to be a fundamental policy of India. It should be something which would impact the interest of the country and should be in violation of the concept of justice and morality. Now, interestingly, that's where fine lawyering comes in. Now, these are such broad contours within which the public policy term has been interpreted that it ultimately ends up boiling down to how well the case was argued, and whether the grounds were, brought in within the meaning of the public policy, and whether you could convince the judge. So there have been instances where we argued the matters in the Supreme Court, and where the trial and the High Court both laid down that this is not in a violation of the public policy, but the Supreme Court ended up holding that no, this part of the challenge, which to the arbitral award, is certainly public policy of India. We are currently faced with a situation, for example, where we have to argue that a particular relief which has been granted by the tribunal to us. So it was a shareholder dispute. There was a joint venture company. There were disputes between the partners. Our client, a PE investment firm based out of Mauritius, sued the Indian company. They got an arbitration award in their favor, but interestingly, the tribunal held that there was insufficient evidence of the quantum of damages, and therefore they gave us, gave our clients a relief of a very nominal damage of 10 crores. Now, our case which need to argue and is pending in the Delhi High Court is whether the relief, a nominal relief of 10 crores, is in violation of the public policy of India, which is making a decree merely a paper decree. So it's a lot of it. It boils down to how you pitch your case before the court. Well, in 2014, in ONGC versus Western Gecko, further the concept of public policy was explained, and it said that it's the three separate heads are duty to adopt a judicial approach, adhering to the principle of natural justice. And now natural justice is that both parties get their chances to represent the case fully. And it also said that decision must not be perverse or so irrational that no reasonable person would have arrived at it. So again, these are very broad contours of what exactly public policy is. And this section would explain as to what are the grounds pre-2015 amendment for challenge and post-2015 amendment. Now, you might wonder as to why do we look at pre-2015 amendment, and because we are sitting in 2021. But there would be some challenges today which would then fall under the pre-2015 amendment, either because the challenge has been pending since 2015 due to some pendency in Indian courts, or the arbitration happened or concluded pre-2015, and you have to challenge it. And I would request Angad to take over and explain from here as to what exactly pre and post 2015 amendment grounds are.
Good afternoon, members of this esteemed, the members of this esteemed chamber. As Samir has very rightly pointed out, the 2015 amendment was a watershed moment for arbitration in India. Prior to 2015, the Indian courts had taken a very progressive view of interfering with all arbitration awards that were passed. There wasn't exactly a strict formula that could be applied that could be said that in these cases only courts come forward and interfere, or what were the grounds in which the courts could step in. Now, as Samir very rightly said, arbitration was brought in to be a fast mechanism of dispute resolution, where people did not have to go to court and the disputes could be adjudicated and decided in a fast manner and not suffer from the delays that normally the court systems do all over the world, I would say, not just specifically in India. Now, the reason 2015 becomes extremely important is because the courts being proactive had actually gone against the international tide of arbitration. If you looked at the international hubs of arbitration, being Singapore, being London, being Paris, over there the courts have followed a concept of non-interference, where they choose not to interfere with the awards that is passed in an arbitration. And even if they do interfere, it's in very exceptional circumstances. Very recently, a study was published where they said that in Singapore, only 99% of the awards that are passed in arbitration are upheld by the courts, and the courts do not step in. Pre-2015, it was seen that courts in India took a very progressive view in the sense that they would step in even if, as Samir mentioned, a second view was possible and the courts didn't agree with the views taken by the arbitrator. Now, although the intention was correct of the Indian courts, the effects that were being felt by the people who had chosen arbitration as a mechanism of dispute resolution, as well as the business owners, as well as businesses, was that despite winning an arbitration and getting an award, they would still be made to languish before the courts for years on end. And that would defeat the purpose of arbitration as a means of dispute resolution. To counter this, the government did take it, realized what was happening and the grievances of the business owners and the hindrances to commerce that was being faced. They passed the 2015 amendment. Now, in the 2015 amendment, the grounds of challenge in a section 34 was severely, if I may just put the slide up first. Yes. Now, as Samir very rightly pointed out earlier, there's very certain grounds under which you can establish a challenge under section 34. Those being an expression of public policy, prima facie illegality. But as Samir said, these were very fluid terms. You would come across various judgments that would include various tests and include various things that could mean to define these terms. And there was no set test. Although the Supreme Court even now says that putting these terms into putting these fluid terms into a strict definition could be counterintuitive, an attempt was still made to define what could possibly form public policy. It was a very fine line that had to be balanced of complete non-intervention of courts, which could obviously be, again, a step in the wrong direction, because without oversight, having arbitrations and no recourse to courts in cases where various things could happen. Maybe the arbitrator didn't understand the dispute or conducted the arbitration in a manner that was not provided for under the agreement. There should have been a recourse provided. However, that recourse could not overstep and render a nullity the entire arbitration proceedings. Keeping that in mind, the government passed this amendment, and in that, the main ground of challenge which was seen and the main change was to the expression of public policy. Now, what exactly did the amendment bring up? The amendment basically saw that public policy against the public policy would mean fraud or corruption in violation of section 75 or 81, in contravention to the fundamental policy of Indian law. Now, again, as Samir said, what is the fundamental policy of Indian law? The fundamental policy of Indian law would not simply mean an illegal act under Indian law, as they said, like in FEMA and FERA violations. It would mean something that goes against the basic ethos or the basic structure, the basic spirit of the law in India as it stands as on date. It would not simply mean that it would go against what is the written statute. It would mean that it would go against every notion of justice that was brought, that continues to exist as on date. The third point, which goes in conflict with the basic notion of morality and justice, is again, in a sense, a slight continuation of the fundamental policy of Indian law, because again, like I said, these are very fluid terms. Trying and putting them in a strict definition was never a favorable approach, and the Supreme Court agreed with that. So what the government tried to do was they tried to create a non-interventional approach where they said that even things had to not only just be illegal, they had to go against the very basic principles of morality, of justice, of the basic policy of Indian law. The Parliament added that the fundamental policy of Indian law now could not entail a review on merits. Why is this so important? As we mentioned earlier, the international approach was for the courts not to interfere with each and every award pass. Now, normally what the parties would do is they would take the grounds of natural justice or public policy and almost treat the challenge process under 34 as an appeal. As Sameer rightly pointed out, and challenge under 34 is not an appeal. It's only in very remote instances where you can file a challenge. Now, if the courts or the government allowed a challenge to be exercised like an appeal, then in a sense, again, we would be back in the pre-2015 era. Hence, the Parliament made sure that fundamental policy of Indian law would never and in no extent be a review on the merits of the case. Hence, if the arbitrator took a view and ruled on the merits, that would be final. You could not re-agitate your disputes and treat the challenge as an appeal. Now, coming down to prima facie patent illegality was also added to the ground for setting aside a domestic award. Now, patent illegality again would be something that was so perverse or so illegal on the face of the award that no person or it would go against, again, basic fundamental policy of Indian law, or no person could have possibly come to that notion or come to that final conclusion while conducting the arbitration proceedings. Now, a provision was further added that the challenge shall not entail merely an erroneous application of law or by reappreciation of evidence. As I stated earlier, this again can be linked with the fact that the courts and the government both realize that it should never be a review on merits. Now, an erroneous application of law could simply be that the arbitrator read the statute in a certain manner that wasn't perverse, that wasn't outlandish, that wasn't so perverse it could never have been read in that manner. It was simply his view taken by appreciation of the evidence. Hence, if that was not completely barred, again, people would misuse the section and come in at 34 and try it as a ground for challenging and using the challenge as a ground for appeal. And most importantly, I would say, an automatic stay of the award filing of an application in 34 was made redundant. Under the previous law, if you filed a 34, there was an automatic stay that you would receive on the arbitral award, and the 34 could continue, and parties would again file a challenge, get a stay, and misuse it for years and years that the matter was pending in court. Now, a separate application for stay has to be made by the person seeking, filing a 34 and seeking a stay on the award, or else just the party who could file an enforcement and proceed to enforce the award regardless of the fact if a 34 challenge had been filed or not. These were the basic changes that were brought in. Again, now when you see the post-15, these are basically the judicial precedents. We could go into that, as Sameer had earlier pointed, fundamental policy which was held in Renu Sagar, and the most basic notion of morality and justice, which was associate builders, as Sameer earlier pointed out. Now, what I was explaining earlier, patent illegality. What is patent illegality? Patent illegality was something that goes to the root of the matter and excludes an erroneous application of law by an arbitral tribunal or reappreciation of evidence. As I had stated, I had already explained this earlier, this is a judgment where the Supreme Court actually held the same to be true. The grounds and these were the subsequent grounds that were held to be a ground for a challenge in under the ground of patent illegality. Now, as I mentioned earlier, pre-2015, a petition under 34 would lead to an automatic stay of the impugned award. Post-2015, that was done away with, and a separate application would have to be filed to be able to get the benefit of a stay and to stay the entire proceedings. Now that we've understood what a challenge was, subsequently, the next section that we have to deal with is Section 37. Now, what is Section 37? Section 37, essentially, the purpose of this section was that a party that is aggrieved by a final judgment or order passed in a 34 proceedings, that is, that the court may have allowed the 34 and set aside the arbitral award, or the court had agreed to not interfere in the 34 proceedings. In such case, a person can file an appeal under Section 37 before the relevant appellate court as provided under the Act. Now, Section 37 also deals with other orders through which you can appeal, such as referring the parties to arbitration or refusal of granting of stay. But since the topic that we're dealing with right now is appeal and challenges, I shall restrict myself only to dealing with the ground of setting aside or refusing to set aside an arbitral award under Section 34. Now, these are again the timelines. I mean, more or less it's 60 days, and if there is a power of the courts for delay if there is a delay to file this, the courts do have a power under the Limitation Act to intervene and to condone whatever delay has been done. However, now to understand what exactly is a Section 37, there are no fixed grounds. Now, as we had mentioned earlier, in a 34, there are fixed grounds under which you can maintain the challenge: patent, illegality, etc., etc., as we had explained earlier. In 37, the section is silent about any grounds. So a person, in a sense, has a chance to reiterate what he mentioned in his 34 proceedings and explain why the judge who had heard the challenge had rightly or had wrongly, obviously, ruled against the party, and how they were grieved for it. Initially, the reason we had mentioned limitation here is because limitation became a very contentious issue. Initially, it was held that the courts did not have the power to condone limitation, and if you had fallen out of the period to file of 120 days to file an appeal under Section 37, no powers whatsoever would be were possessed by the court to condone this kind of delay. This led to obviously a floodgate being opened, especially in matters regarding the government, as the matters regarding PSU and governments normally take a lot more time as compared to those with private parties, because there are several layers of bureaucracy and several approvals that have to be taken by different bureaucrats before the appeal can be filed. And it was seen that such an approach would, in most cases, would actually hinder the availability or hinder the rights of the party to recourse against an order under 34. So in such cases, the Supreme Court very recently passed a judgment in 2021. The Section 5 of the Limitation Act would be applicable, and the courts, if sufficient cause was shown, could condone the delay in filing appeals under Section 37. This was a very welcome approach because it gave the courts enough power to interpret if there was sufficient cause that was shown. And even if there was not, the courts could obviously directly go ahead and not condone the delay and set it and completely refuse to hear the appeal. But in exceptional circumstances where there was a grievance or there was a problem for the party and they couldn't file the appeal in time, it also did not close the doors of justice for that party and provided an opportunity for them to approach the courts and to have the delay controlled. In conclusion, as we had mentioned, pre-2015, post-2015, the aim was to make India an arbitration-friendly jurisdiction and to bring the Indian law in line with international best practices. India, after the arbitration amendment, has become a more arbitration-friendly jurisdiction. It's become, I wouldn't say it's become a hub like Singapore, but it definitely has those aspirations and is taking steps in the right direction. And with as we explained, this change in Section 34 and 37, these have been welcomed and by the international community at large, and especially by business owners, because it makes the entire process a lot more understandable, it's accessible, and a lot more streamlined. And finally, as we said, judicial intervention has been made minimal so as to promote arbitration in India. I hope this was useful to you. I have seen there's a question that someone, Renuka, had placed. Is there any website to see the status of arbitration proceedings? yes, there are no websites as such. You will normally, so let me just split this question into two parts. You can go into it for an institutional arbitration, which is run by an institution such as the ICC, or in the Delhi High Court Arbitration Center, or the Singapore or SIAC, the Singapore International Arbitration Center. Here, a center conducts the arbitration through its rules. So there won't be a website, but there will be a case management officer that is normally assigned to you. And whatever status, whatever doubts that you have, you can ask him and he can update you. And it's a very streamlined process. So you have access to everything, right from the orders passed to what happened in the proceedings, to the transcripts of the entire proceedings for the day. Those are provided to you by the institute itself. In the second part, where it's not an institutional arbitration and it's carried out on an ad hoc basis, even then, you can write to the arbitrator, and firstly, after every hearing is concluded, you're provided a copy of the final order or the evidences and the proceedings that took place on this date. Even if you happen to misplace them, or you can write to the arbitrator and you're provided whatever information you require, whatever you need immediately. So I hope that that was helpful. There's another question that's coming as answered by Renuka again. During the arbitration proceedings, the grounds under 34 cannot be invoked, or these grounds are only available for setting aside the arbitral award. Now, 34, as we said, is a challenge to the arbitral award. However, I'm sorry, let me just get to these questions later. Yeah, coming back to what we are answering. In the 34, they're the grounds for challenge that you get after the award has been passed. But in a sense, when it comes to grounds such as patent illegality, those grounds will never be available to you, because you will never know. That ground will only come into existence when the award has been passed. And you see that the award suffers from patent illegality or goes against the basic fundamental principles of India, or if any other grounds. But if you have in certain grounds, such as the dispute was not amenable to an arbitration, or the contract was not executed properly, which was also ground under 34, those grounds can be taken, and which exist already during the time of the arbitration, can be taken as preliminary objections in the arbitration itself, and the arbitrator can rule on those grounds. So although the grounds as they are present in the Arbitration Act are only available during arbitration, during set challenge proceedings, if those grounds are available, like as I mentioned earlier, you can take them as preliminary objections during the course of the arbitration as well. I hope that was helpful. I think there's another question by Laura. How does Paris work as a site for international process in terms of price and duration? A company tried to read London and Geneva at most times. So in fact, Paris is the center for the ICC, which happens to be one of the oldest institutes that conduct international arbitrations. They were probably one of the most renowned institutes till a certain while back. Now, obviously, LCI, the London centers, the Geneva centers, as well as Singapore, which is coming as an international hub for arbitration, are at the same level. However, Paris, from the experience we've had, has been a very streamlined jurisdiction for the conduct of the arbitration proceedings. They have a good infrastructure available. They have a trained staff. They have trained arbitrators on their panels who are extremely good at the subject matter of the dispute, which could be something that could range from a basic civil works contract, international sale of goods. They have expert arbitrators who have dealt with these kind of topics day in, day out, and are well suited to adjudicate upon this dispute. In terms of cost, it is a common misconception that the ICC is extremely expensive as compared to Singapore or the Asian centers. I agree, it is slightly more expensive, but not to the extent, but I would say it's probably just 15 to 20% more. The advantage you get is probably for European parties, you save a lot on costs. You have a center that has been doing these kind of disputes for a while, and the comfort level for parties, because if you're a European party, if one party is British, the other party might be German, they'd be more comfortable with a dispute in Paris rather than a dispute in Singapore. When it comes to London, we've actually done one arbitration in London as well. London was the most expensive when it comes to the fees of the tribunal, the fees of the institute, because they almost charge on the basis of a pro rata basis of the claim, as well as an hourly slab rate, which comes out to be much more expensive than the fixed rates that are applied by the ICC and the SIAC. So as compared to London, I would say Paris was a cheaper alternative, definitely. As compared to SIAC, Paris was slightly more expensive. But again, as I said, the facilities, the infrastructure, the pool of arbitrators, the case management officers was simply outstanding. Geneva, we've only advised on an arbitration. We haven't, I haven't, Samir has, I haven't personally arbitrated in Geneva as recently or as yet. However, I have heard good things, but Geneva is not, I mean, and that's my view completely. Everyone is allowed their own view on this. I would say Geneva is still an upcoming center. It's not at the same level as the Paris and London centers, as well as Singapore centers, in the sense that these centers have been running, and the sheer amount of arbitration that they've been dealing with, they've streamlined their processes. Their rules are magnificent. They've been adopted they've adopted all the international best practices, and the pool of arbitrators and the pool of practitioners makes it much easier. And this is just my view, to arbitrate in Paris or Singapore instead of Geneva. I hope that was helpful, Laura. Coming to the chat box, there seems to be a question by Mr. Subrat Nath. We as a Spanish company prefer opting for London or Singapore as arbitration center. Do you recommend that we choose India going forward? So that's a very good question. This question, we've been asked this question quite a few times. Let me break down the answer to this. Firstly, I think depends on the comfort level of the parties who are putting the clause to arbitrate in their contracts. London and Singapore and Paris are established hubs for arbitration. There's a belief within the parties that the arbitration process is better there. The courts have a non-interventionist approach, and it's easier to arbitrate there. India, as I'm extremely proud with the way the Indian arbitration the jurisdiction and jurisprudence is developing. It is definitely taking steps in the right direction. There are institutions that have now been formed that conduct these arbitration proceedings. There are a good pool of arbitrators who are appointed even by these international institutions, and a good level of practitioners who are practicing solely as arbitration as their main speciality, rather than a couple of decades ago when arbitration was considered just to be a weekend practice and never the main practice. Just simply saying India is taking steps in the right direction, but it completely depends on the comfort of the parties. If they are willing to keep India as the venue or the seat of the arbitration, I would advise, yes, why not? It's taking steps in the right direction. It's definitely cheaper to arbitrate in India, and it has a good amount of experts and people who are proficient in the field, and I would definitely recommend India as a seat for arbitration. If there are any more questions, I'd be more than happy to answer. As of now, I can't see any. I would again like to thank all the members and all of this esteemed chamber who took their time out in this afternoon. And thank you all for giving us such a patient hearing. Thank you.
Okay, so thank you very much, Angad, for the presentation and for the questions. Okay, so I think, as I was telling initially, maybe not all of us have a legal issue, but some of us have a legal issue because of the questions that were there. No, so no, thank you very much to both of you, and thank you to all attendees, okay, for being part of this webinar. And okay, please send your feedback or share your feedback about this webinar so we can prepare future ones according to your wishes and your expectations. And that's all from our side, or from my side. Okay, thank you very much to all of you again.
Thank you so much.
Thank you.